Hi there, everybody. Good afternoon. We're going to start this lecture on tenant alterations and leasehold property. First of all, to introduce myself, my name is Tristan Salter. I'm a barrister here at Five Paper. As I said, I'll be speaking to you about tenant alterations in leasehold property and providing some insight into why that is relevant for conveyancing specialists. A little bit of housekeeping to start with. You'll probably all be on mute already, and I'm told you can't take yourself off mute. So if you have any questions, please either raise your hand or post them in the chat box. I'll try and answer them as we go along and or at the end of the session. If they're particularly difficult questions, I will make sure I get back to you with an email with the answer. That will do. As I said, I'm speaking to you about tenant alterations today. And I wanted to first give you a little bit of background about myself. I specialise in property law, and that's from possession proceedings to the various leasehold applications that are brought in the various tribunals, to a bit of a specialist area where property and insolvency issues overlap in terms of bankruptcy or commercial property in a winding up scenario. In the context of purchases of property, I'm often brought in to advise where a sale has broken down in the case of negligence or deceit in relation to different transactions. One case involving waterways, and probably like many of you, I've had a case involving the lovely Japanese knotweed, and in that case, it was hidden underneath some plastic matting and then some fake turf when it had been bought. But I have to admit, conveyancing itself remains a bit of a mystery to me. If you say anyone that you're a lawyer, they first ask you if you do criminal law and if you've just got any juicy murder cases. When you say that you do property law, they start telling you straight away about the conveyancing process and how long it takes. And that's the luck of property lawyers. And I am not a conveyancing expert at all, probably not like you guys, but I am an expert on issues around leasehold alterations, forfeiture and other applications that are involved in that. It is also an evolving issue, and one of the problems that I'll come back to later is what leaseholders think they can do when they, or quote unquote, own the property. So what I'm going to be talking about, I'm going to be looking at how you can identify issues in a leasehold alteration scenario, especially from a conveyancing perspective, how consent can be provided, what is unreasonable withholding of consent, and the issue of collateral contracts and their effect following the Supreme Court case of Duval. So I wanted to start first with a scenario. This was quite an easy scenario to find. It's one I looked up on the internet, and this came from the Camden Leaseholders Forum. Essentially, it was this, that Party A was trying to buy a leasehold flat from Party B. In the course of the sale, it comes to light that two walls, one in the living room and in the bathroom, have been removed. The question on the leasehold forum was, my conveyancing lawyer is holding up the sale to try and get this dealt with. Are they just trying to waste my time and add up extra costs? And we will see, and we will tell all our clients, no doubt, that actually we're trying to protect them, potentially from themselves. But I think it's worth making a wider point at this stage. This situation, or where leaseholders get into problems with alterations, it's all too common. And I think it's from a misguided view that most people have in when they have a leasehold property, that they actually own the property rather than have it on a very, very long lease. This is even further intensified when we're dealing with a share of freehold. Those individuals really do think they own something. But as we know, they just have an interest in the land, and actually the landlord controls and owns that building. So I'm going to come back to this scenario where someone is, Party A has removed, has looking to buy it, and Party B has said, well, look, there are some problems with it. As we go through this lecture, just to sort of touch base on where there can be issues going on and how we can resolve them. So from our scenario, the first thing I want to highlight is that we have to look as lawyers, but in particular when you're doing conveyancing, the job is the early identification of issues around alterations. I've put up a lovely cover of the floor plan there that you'll often get in a situation like this. But one of the problems is walls, floor coverings, windows, the elevation can all change. And it's important as the lawyers dealing with it that we actually look at those changes and say, okay, something's gone amiss here. There may be a floor plan change from an earlier lease or an early version of the lease to the floor plan that's produced by the estate agents. So if you've got that earlier, well, not earlier lease, but the earlier version of the floor plan, you want to make sure that, quite simply, all the walls are in the same place and the windows and the floor coverings align with what you're seeing in the pictures. There is a great deal of praise to be said in this scenario that we posed at the start, is the lawyers identified quite early on that the floor plan was not the same as the floor plan in the lease. And while it sounds like a simple matching up exercise, obviously walls being very easy, you'll be surprised how difficult it is, for instance, with carpeted areas of flooring, windows, the types of windows that are installed, openings that might not make it, and other changes that are made to the layout of properties. So the first point in relation to conveyancing and the alterations is identification of that issue. Because if you don't identify it, quite frankly, we can't try and solve it. But the next point to make is who has made the alteration. In the scenario I posited, I highlighted that the alteration had been there, but I didn't tell you who it had been made by. I deliberately left it vague about who had made the alteration and the basis of, was it the vendor or was it the previous owner? In one sense, it doesn't really matter. Because in a conveyancing process, it's quite easy to say that we need to take a risk-averse approach. And let me explain why I say that. An obligation not to do something, unlike a breach of a covenant to repair, is a once and for all breach. It's committed by the tenant the moment the alteration is made. So the moment they take down that wall, that is the breach of the lease. In a repairing situation, you may well know that if you covenant to keep something in repair, every day that it's not in repair is a new breach. So it's sort of a continuing breach. So this has some implications, and you might think they are quite useful implications, but I'll tell you why they're not altogether so useful. The first is that there is a limitation period, and it would be 12 years from the date of that alteration. Secondly, an assignee would not generally be liable for a breach of covenant against alterations and therefore not liable for damages. However, a much bigger risk continues, and the risk of forfeiture does continue for assignees as well. And this is most adequately shown in the case that I've highlighted there, in the case of Triple Rose Limited versus Patel from 2018. In that case, they were just seeking a determination under 168 of the Common Hold Leasehold Reform Act. Now, you'll probably all know very well that that is a precondition for the service of a Section 146 notice and forfeiture. So someone was going to the tribunal saying, we want a determination that there has been a breach of this covenant. In that case, at a previous point in time, but no one was able to say exactly when a window had been replaced by a door that accessed onto a flat roof. Now, again, it was common ground in the case that the flat roof had not been demised to this leaseholder. So what they had done, or someone had done, is essentially taken possession of that flat roof to give themselves a nice balcony space. Now, again, one of the very common alterations that you see is people trying to get a little bit more space, especially if it's a floor space. In the lease itself, there was a covenant not to make changes to the elevation of the building. Now, there was a discussion about what elevation meant and whether it meant the front of the building or the back of the building, but the court said it meant anything to do with essentially the facade of the building, so front or back or anything like that. The upper tribunal also found that if there was a breach, even if it was committed by the previous owners, and indeed no one was sure when the windows were this new door was installed, but it must have apparently been post 2002, and the lease was granted in 1990, because that's the date that this window apparently came into sort of circulation, according to expert evidence. But what they did is said, well, they made a determination under Section 168 that there was a breach, and there had been a breach of the covenant. Now, as I said, that's hugely important, because that breach finding under 168 is the condition towards the service of the Section 146 notice now, and that's the precondition to forfeiture, which obviously is the loss of a huge asset to someone. So you can see now that where that risk of forfeiture continues, there's a huge loss for individuals that essentially live with alterations that haven't been consented to. And it was common ground in that case in Triple Rose that there had been no consent to this alteration. There were complex questions about whether or not the landlord knew about the breach and about whether or not they'd waived the breach, but the upper tribunal said that's not for us to decide, that's about a forfeiture issue later on. And from sort of my point of view, given the size of the asset that was in place there, you are looking at the clients actually saying, well, look, I'm going to have to put back the alteration because I can't risk a determination under 146 and then forfeiture proceedings in that way. It's just not important. So the question about who has made the alteration, while interesting, and if it is the vendor themselves, it's going to be more important. If it has been previous owners under the same lease, then it's also likely to be important because of that risk of forfeiture. So from a conveyancing point of view, you're going to want to make sure, if you're acting for the buyer, that the seller does get the necessary permissions, and it won't matter that they say, oh, it's been like that for years and years. That might help with getting permission for it, but it still means, in my view, that they should get permission before the conveyancing takes place. So if we've dealt with our identification of the issues, we then dealt with who has made the alteration. We then need to think about the covenants itself. And there are two ways to think about covenants in relation to alterations. It's the two C's, it's classification and coverage. There are three types of classifications of restrictions. Again, this is probably well known to you. They are absolute covenants against any works. They are restrictions of alterations without prior consent, and then restrictions with alterations without consent, which may not be unreasonably refused. Those are the sort of classification of the restrictions, and I'll be talking about firstly absolute ones and then partial ones or qualified ones in a second. The important point to then look at is there are many types of coverage. So each lease will be very different, and it will look at different types of coverage in terms of those alterations. And there, in most leases, there's obviously a blend of the classification and the coverage, because there will be absolute prohibitions on mainly structural elements, but there might be qualified conditions on other aspects. Now, I put down some of the usual wording that's used in leases. Quite strangely and quite archaically, it still uses words like cutting and maiming in relation to walls. But it's very important because it might go in relation to ceilings, or it might go a little bit further, or it might go on to joists. And so each of the alterations that you're looking at will have a different scope in terms of the coverage they're dealing with. And the key point here is that each lease will be different and they need to be married up to the alteration in question and the coverage that they represent. So if we go back to our scenario and look at absolute covenants, as you might understand, they say you can't do this at all. Okay, that's not strictly true. You can get a license for works which breach an absolute covenant. An example of such is the case I highlight there, it's Hardy v. Elliott. In that case, there was a clause requiring the covering of floors with carpet and underlay. And there was essentially a finding that although this was expressed as an absolute, it was a bar on essentially not having them in terms of the works that need to be done. In that case, in Hardy versus Elliott, permission was sought by the tenant for alterations, which included the installation of hardwood floors, among other things, which was granted. This then highlights a tricky issue in leasehold properties, which is wood floors, noise, and sound travelling. Essentially, in the Hardy and Elliott case, they allowed these works to take place. The scope of works included hardwood floors throughout the property, and the landlord said yes to it. Other people then objected to the hardwood floors because essentially it was causing so much noise. In the judgment of the Court of Appeal, the court found that the clause to keep the property carpeted had been waived by implication due to the agreement for a license for these alterations, which included the wood floorings. So in that case, the license allowed them to essentially breach that absolute covenant by essentially giving them a license for works to take place in a variation. However, there's a warning to that, and that's the case of a Block Building Management Company versus Wilkinson. This is just a county court case, but it highlights the point that injunctions will be granted by the court for reinstatement of works. In that case, there have been complex works undertaken by the tenant, including the repositioning of plumbing and electrical works to their flat. And the court said, no, you can't do that. There's an absolute covenant against that. There's also a fire safety risk. And essentially, we're going to order you to reinstate the old layout and the old situation of the works. In that case, it appears that the works have gone quite far. So you can imagine the expense of all of that money spent doing the work, and then probably even more money spent trying to get it back to a position that it should have been. And that's the problem with absolute covenants. They can be quite easily enforced, and the courts are willing to enforce them because they are absolute in terms of what people know about them. Now, they do often only attach to the structure and include words like cutting and maiming. And I'll come back to those kind of phrases in a second when talking about Duval. Now, qualified covenants is then more interesting. Qualified covenants and are ones which allow you to do works, but they say, oh, you need our permission or you need some consent. Now, that qualified covenant is then impacted by statute, which is section 19.2 of the Landlord and Tenants Act 27. I'll put the full text there, but I'm quickly going to get that off your screen because it's pretty dense and horrible, and it's from the 1920s, so it's not great reading. But essentially, if you have a qualified covenant where consent is needed by the landlord cannot unreasonably refuse that, especially for improvements. Case law says that improvements are to be judged from the point of view of the tenant, but that the tenant also bears the burden of proving that a landlord unreasonably refused. In terms of that refusal, a landlord can either do one of almost three things actually. They can explicitly refuse and say, no, you're not doing that. They can set some unreasonable conditions, including documents they need, payment sums, or they can simply not respond. And essentially, the tenant, if they believe that there has been unreasonable refusal to do the works, can just carry on with the works. And that is obviously a difficult position to take, and most tenants will want some backing from the courts. It should be highlighted as well, when there's a qualified covenant, it doesn't stop a landlord asking for documents or payment of sums, but they must be essentially reasonable sums. And we're looking at essentially management fees or a survey or structural engineer's report to say, look, this is safe and this is what we need to meet building control. I often see landlords say, well, this is going to cost us X amount of money. And actually, when you look at it, it's not, as long as the information is provided by a reasonable surveyor. But often that breaks down in the communication of who is actually going to investigate and look at the alterations that take place. That's section 19.2, as I said, of the LTA 27. They're not included from requiring payment or having conditions, but they have to be reasonable. So in our scenario again, if there was a qualified covenant in relation to the walls that had been knocked down, we would have to look for communication to say that the landlord was put essentially on notice and had been asked for consent. There's no formal process of asking for consent, no prescribed form, as you might imagine, but the communication should be there to say, look, this is the lease term. We want to have consent to do these works, and normally a timescale for replying to that. That would all help you in a conveyancing situation. Say, well, they asked for it, and we can say you unreasonably refused those works. It then also helps if the works have actually been signed off as well. This year has been quite interesting as well, because this year has been a year where there have been two cases all about reasonable or unreasonable withholding of consent. So in the two cases that I highlight, they come from very different scenarios, but they give us useful points about what is reasonable or not. So in the first case, in the Metset property in Lanark Square, this was quite, what you might say, quite an extreme case of alterations. This included the building of another floor onto commercial property. The court made the point that a section 19.2 application to a landlord does not have to be made any formal way, but saying it's obviously better if you say what you want, why you want it, and how you're going to comply with relevant conditions that you think are reasonable. You can't just say to someone, oh, this is what I want to do, and I'm not going to put in any protections. So that's very important. The court also said, and quite crucially, that where a landlord provides a full number of reasons why they are not going to provide consent, they only have to get by on one, and this can make it difficult. Landlords will often give maybe 5, 6 reasons why they're not going to give consent. And the court said, well, only one of those reasons has to be reasonable. And as long as there is one reason that's reasonable, that's enough to refuse permission. In this case, it was unreasonable to refuse permission based on issues such as trespass to their sort of adjoining buildings, and it was reasonable to ask for structural engineer drawings. Quite how this case progressed when they didn't have structural engineer drawings about the development, really we'll never know, but that was the reason for refusal. It was one of many, but it was found to be reasonable. We can contrast this case with the case of Jacobs in Chalcott Crescent. In this case, the leaseholder sought alterations to a converted terrace property. much more normal in terms of the scale of the works that we come across, or at least I come across on a normal basis. At first instance, the judge said that consent had been reasonably withheld because of an issue, he said, with structural integrity and to do with fire safety. However, this was overturned on appeal because the issue was found not to have been actually pleaded, and the court said it's an important part of the adversarial system to say exactly why you refused in your pleaded case, as well as in the documents. Essentially, this structural integrity issue, I think, as trial develops, got more and more interesting and more crucial to what took place between the parties. But what I think is even more crucial in Jacobs, and this gets lost a little bit in Jacobs, and the commentary on it, is that the court also said the reason must be supported by evidence. Now, that kind of makes sense. But what in that case happened is that they had an expert report and said, oh, there could be an issue with structural integrity of the building, but you're going to need another expert. Essentially, it's one of those expert reports that says, oh, I'm not a good enough expert to find this. You're going to need a different expert. And to that degree, sometimes you'll find yourself in litigation sort of chasing more and more experts in a sort of line of how expert are you going to be about a very small issue. And the court said, well, look, this expert said you need to find another expert, and you didn't go and look for that other expert. So they're only giving a sort of qualified opinion about whether or not this structural integrity issue even exists. And I think that's really important as well in terms of when you're looking at people refusing consent, if you're asking for it, whether or not in the conveyancing process or not, saying, well, why are you actually saying this? You can't just say fire safety or structural integrity without proper evidence to back that up, especially if the alteration has been there for a significant period of time. What we then come on to is what's been the really big change in the law and case law around alterations in the last sort of probably 5 years. And that is the case of Duval. Duval, as you can see from the heading, went all the way to the Supreme Court, and it really was quite an important case in relation to both leasehold dynamics and in particular alterations. So this is what I call the fourth restriction. It's about collateral contracts and the restrictions that are in place by collateral contracts. But let me explain first of all Duval. The Randolph Crescent estate was 9 blocks of flats. Each was let on a long lease. One of the residents wanted to undertake works to their own flat, which included the removal of an internal non-load bearing wall. So that was the works they wanted to do. And they then looked at the covenants in the lease and asked the landlord for consent. There were 2 covenants in the lease. First of all, there was clause 2.6, and that was a qualified covenant on improvements. And there was then clause 2.7, which was an absolute covenant on maiming or injuring the walls. Now, if we look at that, and especially the words cut, maim or injure, or suffer to be cut, maim or injured, any roof, wall or ceiling, you can understand that that can be first looked at as quite a wide term. Because, for instance, if you're a bit like me and you're trying to put up a picture, okay, on the wall, you could be said to be injuring or maiming the wall. You're piercing it, you're putting something in the wall. Does that extend to, for instance, putting a new electrical socket? You might be putting a new socket, you might be injuring, cutting out bits of the wall. You can see that that kind of language, although very highly prevalent in leases, isn't that clear. Well, the court was first essentially alive to the issue of where there are qualified and absolute covenants which go and sit together and say, okay, we're going to look at this a little bit differently. So the Supreme Court said, and this all comes from paragraph 32 of the judgment, that the two provisions, 2.6 and 2.7, are meant to be read together as part of the whole lease. And they are directed at different types of activity, and maybe not the strict letter of the clauses themselves. So clause 2.6, the qualified clause, was concerned with routine improvements and alterations to the flat. So little things that need to be done in the flat, and essentially you need consent that should not be unreasonably withheld. By contrast, 2.7 is directed at activities which are much more serious, and they go beyond routine alteration and improvements, and importantly, they said intrinsically such that they may be damaging or destructive of the building. So there's an absolute prohibition on things that might damage or assault the building. Now, that is really important because it highlights that you can't just click on a clause and say, oh, there's the clause that says you can't cut, maim, or destroy, and it's breached because this is what you want to do. Unfortunately, you have to look at the alteration clauses and how they operate together as one. So they'll all be slightly different than leases, but many leases have this kind of language and approach, which is essentially qualified on small works, but absolute on large works. This is still a problem though, because if you're trying to remove a non-load bearing wall to the property, where does that fall within that? And this wasn't really answered in this case, but you can see it's probably more than routine, but it probably doesn't damage or destroy the building itself, but it doesn't damage and destroy the floor plan of the building. So essentially they said, well, look, you've got to look at this a little bit more carefully. The important point about this was essentially this reasoning came out of the Supreme Court itself, and it didn't really come from either of the parties who'd been arguing something different. Now, that was all well and good, and that might have been an interesting Supreme Court case, but it wouldn't have been seismic. Why it was seismic was because of the next clause, which was clause 3.19. Now, 3.19 essentially said that there is a collateral contract, and that said that at the request of the tenant and subject to the payment of the tenant and provision provided of security for the costs of the landlord on a complete indemnity basis to enforce any covenants entered into with the landlord by a tenant of any residential unit in the building. So essentially, this is a clause in the lease which says I will enforce other covenants in other people's leases. Now, there was a big debate in the Supreme Court case about, oh, well, actually, the tenant that requests you enforce must have to pay for money, and they must pay that money before alterations are made or before we grant consent. Because the Supreme Court said essentially no. And the reason they said no was that a landlord cannot put themselves in a position where it's in breach of a covenant and cannot enforce it. So it can't offer a license to alter, to do works where it will be in breach of its ability to enforce another term of an agreement with another party. So that's really clear in relation to absolute covenants, i.e. you won't be able to enforce this absolute covenant in the future if requested by the tenant. I think, and I've given this lecture a number of times, I think it also has an impact on qualified covenants where the procedure has not been followed. Often in the case of qualified covenants, there's a procedure to be followed in relation to alterations, and a landlord cannot put itself in a position where it hasn't followed that procedure to the letter, and that's quite important too. But essentially, it goes to a point that alterations cannot just be controlled by the landlord and the leaseholder. There might be some control by the other leaseholders saying, well, look, you've actually got a collateral contract with me not to do certain things. One of those is likely to be more and more alterations that affect the structural integrity of the building. So the Supreme Court decided that there was implied term in the lease that landlord would not put out of its power an ability to comply with the covenant by releasing one of the other tenants. In other words, you can't promise two things. It's also important to highlight that the court took a really practical view of the covenants within the lease. And it said essentially that works might be anticipated in the future. You would have to essentially go around and ask all of the other leaseholders for consent to those works. That is obviously going to be somewhat practical in the Randolph present estate, where there were 9 other flats, so maybe 10 people that you have to go and talk to, where you can obviously see other situations where you've got tens or 20s or even hundreds of other flats that have been impacted by this. But putting the Val in context, because it was a huge case, does it give leaseholders more control over alterations that take place in other people's property? Quite clearly, yes. And that can make it more difficult to get permission for alterations that have occurred either in the past, and increases the scope of things going wrong in terms of if you are purchasing a property and there are issues around the either internal state of the property or improvements that have been made that have not been consented to. As a sort of secondary point, and just something to think about as you go away as well when you're advising your clients. And if you've got share of freehold, you might also have to think about directors' duties. Sometimes, not always, they'll be part of a freehold company that holds the estate, holds the freehold in a company, and that might have issues in relation to how alterations have been granted or not requested or not enforced. And if you are buying share of freehold, it's another important angle to highlight to those that are buying share of freehold. How is that freehold actually held? If their bit is held by a company, well, then you've got duties as a director. Have those duties been complied with previously? How are you going to comply with your duties as a director, not just as a leaseholder? Few people, when they're buying share of freehold, really realise that they're also entering into a company arrangement like that. And especially if things have gone wrong in that company, it's very important to deal with it head on. So some sort of final concluding remarks this lunchtime. First of all, in alterations situations, early identification of the issues, matching up floor plans, matching up pictures, identifying where, for instance, if someone's installed new hardwood floors throughout the property, there isn't a covenant to keep those carpeted. Most old leases will say everything needs to be carpeted, bar the kitchen and the bathrooms. If people move that bathroom around the place, you have to question whether or not that area needs to be carpeted or not. No one really wants to have a carpeted bathroom anymore. Do the works allow for a simple request in terms of is it easy to just ask for permission from the landlord, even if it's retrospective? Question whether or not the landlord is bound or very likely to enforce. Are they bound to enforce an absolute covenant? Are they likely to enforce because there might be some kind of risk? Or are they likely to enforce because there are collateral contracts with other people within that lease to uphold the covenants within the lease in question? And finally, question how long that alteration has been there. It might not be a complete answer to the situation about whether, especially if you're buying, your client might not have an issue with that, but it might go to whether or not permission is likely to be granted, because you may have more evidence in terms of building control, and you may have more evidence that actually no one is likely to enforce that. But essentially, alterations have got slightly more complex. In my experience now, because of Devolve, we've had a bit of couple of years of settling down for it, landlords are much more aware of this collateral contract that is there, and they're much less likely to grant permission for alterations that they would have done in the past that would have breached an absolute covenant. Landlords were quite flexible in that approach as long as they could get relevant sign-off. They weren't too bothered if someone was essentially improving the property in the estate. But now it's more complex because lots of leases have this collateral contract. It's not often in the same place as the alterations covenants, but it can be quite easily found and relied upon, especially in small estates where people are essentially worried about what people are building or doing, or most importantly, in the cases I see a lot, is the installation of hardwood floors, which cause huge amounts of noise to people. So that's been a rundown of alterations and the present law on it. If you have any questions now, please put them in the chat box, or I think you can raise your hand. I think these slides will be sent out alongside the recording if you want them or want to share them with any of your colleagues. But I'll be around for the next 5-10 minutes for any questions if anyone has. If not, don't know if that one, or if you think of something, please feel free to email me and I can respond to you about it with any questions that you've got. Okay, I don't think there are any burning questions from people. So thank you very much for listening. If you do think of anything, please just let me know. I'll be happy to answer any of your questions.
Thanks very much, Tristan. That's been really helpful, and we will circulate the recording to everybody along with a feedback survey as well. And I'm sure if anyone has any questions that they'd like us to direct to Tristan after this session, then if they send them to me and I'll forward them on. But thank you very much and have a great afternoon, everyone.
Thank you very much.